Hi, my name is Janice Switlo, and I want to pick up on my previous comments that I've made regarding the J Treaty in the episode titled J Treaty Binds Canada. People may respond to that and say, oh, well, it's already a decided issue. There were at least two major Supreme Court of Canada decisions, and that decides it. I want to take you through in two parts, because it might get too long in one session. I'm going to take you through the Francis case in part one, and in part two I'm going to go over the Mitchell case, so that through that you'll get a better understanding of why I say this is not a done issue. This is not settled. It should just be beginning. Just because no one has approached it in a proper manner doesn't mean it's not possible. So turning then to the Francis case, this is a 1956 case that the Supreme Court of Canada decided. And the appellant, I'm quoting from the head note, the appellant, an Indian within the terms of Section 2, Sub 1, Sub G of the Indian Act of 1951, resided on an Indian reserve in the province of Quebec, adjoining an Indian reserve in the state of New York. So clearly he's being defined, he's in court, seen as an Indian as defined by federal legislation. He's not there as a national of his own Indigenous nation. In 1948, 1950, and 1951, he brought from the United States into Canada certain articles acquired by him in the United States, USA. No duties were paid in respect thereto. The articles were subsequently seized by the Crown, and the appellant, under protest, remember, key, under protest, paid the sum demanded. By his petition of right, he claimed the return of his money and a declaration that no duties or taxes were payable by him with respect to these goods by reason of the above part of Article 3 of the J Treaty, and this claim was rejected and then appealed and then again rejected. It's important to understand how in Canada we operate under a system of law called precedent. So basically, whatever's been decided previously forms the case law, and we are required to be bound by that and carry it on. But as was explained, as I was taken aside in law school and explained to me very carefully, there are two kinds of lawyers. There's a lawyer who simply does as they're told and fills in the blank and perpetuates the precedent. But most importantly, there are those rare lawyers who look at the law and say, based on these precedents, it's gone down a bad path. This has become bad law and it needs to be changed. And we are no longer accepting of certain concepts or biases, or racism, for instance, that allow us to propagate and build upon that foundation. We have to tear out that foundation and put in place a new one and start fresh and create the path that's necessary that matches our understanding of fairness and law and justice today. So what I'm doing then is describing here the attitudes back in 1956 and why this case, for instance, can no longer be considered good law. Per Justices Kellogg and Abbott, the provisions of the Indian Act constitute a code governing the rights and privileges of Indians, and except to the extent that immunity from general legislation, such as the Customs Act or the Customs Tariff Act, is to be found in the Indian Act, the terms of such general legislation apply to Indians equally with other citizens of Canada. And no such immunity is found in Section 86, Sub 1 of the Indian Act. With other citizens of Canada. This was 1956. At that time, quote-unquote, Indians were not allowed to vote because they were not seen as citizens of Canada. They were considered aliens. They were foreign nationals of their own Indigenous nations. And because of the legislation that was passed in order to create, the emphasis of establishment of actually being such a thing as a Canadian citizen, none of those acts could apply because the Indians weren't enfranchised. They hadn't given up who they are and they hadn't asked to come under, and they were not, definitely were not under Canada. They were, as said, clarified and understood to be aliens and foreign nationals. So what to do? Canada in 1960 simply passed legislation and deemed all Indians to be actually citizens of Canada. These people did not apply for citizenship. Canada just deemed it to be so. So how can a Supreme Court of Canada say they're bound by federal law equally with other citizens of Canada as being citizens when they're not actually citizens? Now, the Chief Justice of the time described that, the supplicant is a Indian resident in a reserve in Canada. And he falls within the definition of Indian, as said, and at all relevant times he resided on the St. Regis Indian Reserve in St. Regis Village in the westernly part of the province of Quebec, which adjoins an Indian reserve in the state of New York in the United States of America, the residents of both reserves belonging to the St. Regis tribe of Indians. You actually have, and this is there, and as I said, they were not citizens of Canada. They were nationals of the St. Regis tribe of Indians. These articles were brought into Canada in the manner already described in order to lay a foundation to run this test case. So, again, you have this inability for the top court of the country to properly describe who this person is. So it's speaking about, this is a case where vested rights of property are concerned. This is not a case where vested rights of property are concerned. It's unnecessary to consider the question whether the terms of the Jay Treaty were abrogated by the War of 1812. He says, I agree with Mr. Justice Cameron that Clause B of Section 86 of the Indian Act does not apply because custom duties are not taxes upon the personal property of an Indian situated on a reserve, but are imposed upon the importation of goods into Canada. Now, remember, this went from reserve on the U.S. side to reserve on Canada's side. A reservation out of treaty, these reserves called reservations. Reservation out of treaty is where no permissions have been provided. This is where jurisdiction remains whole, although obviously Canadian governments have interfered with that. And for example, if you look at the income tax quote-unquote exemption that's referenced, it's not a matter of Canada granting an exemption to tax on reserve. It's the fact that Canada does not have any jurisdiction to tax on reserve. And here we have, were these goods actually going into Canada? They were going into a reservation, and in the reservation, that's a reservation outside of any treaty, any promises, where that has been considered and remains fully within the jurisdiction of the Indigenous nation, subject to any permissions to administer and such that were set out in a treaty. Now here it says, I cannot agree that any relevant rights of the appellant within that treaty are justiciable in the courts of this country. That's right, you cannot enforce international treaties in domestic courts. So that's another confirmation of some of the things I often talk about. Just bear with me a little bit. I know reading law and dealing with legal cases is not the most exciting, but these are important concepts to understand. What were the basis? What were these people thinking? What were these men thinking when they rendered these decisions? Well, let's look at what was also said at that time. A treaty is primarily an executive act establishing relationships between what are recognized as two or more independent states acting in sovereign capacities. Here you have the Supreme Court of Canada defining what a treaty is. Well, treaties 1 to 11, all these other treaties that exist. The Crown lawyers did not write agreement at the top. These are not domestic agreements. Specifically, the word treaty was used. And as indicated by the Supreme Court of Canada in 1956, when you have a treaty, an actual treaty, we're not talking land claims, those things weren't even created yet. A treaty is primarily an executive act establishing relationships between what are recognized as two or more independent states acting in sovereign capacities. Now, I'm also going to reference in here another point. Some people have mistakenly referred to treaties, like for instance, treaties 1 to 11, as peace treaties. And I've come down hard on these people. And I've spoken about it, and I will be speaking about that in an episode if I haven't done so already. I think it's on the list. Here's what the court reminds here. In a peace treaty, the transfer of sovereignty over property occurs. There was no transfer of sovereignty. There were permissions granted to the Crown. Just look in those treaties and see the words to have and to hold. Those are leasehold terms, and I'll be dedicating a session to explaining those in detail. You will not find those kinds of terms where you've seen other states, other nations who have gone to war and signed a treaty of peace and are divvying up the property and transferring actual ownership. That is why it's so critical to never use those terms. Because you're saying at the same time that you transferred your sovereignty, all of it. And let me just see if there's anything else here I wanted to flag for you. Oh yeah, sorry. There's another whole page here. Okay, and I want you to think about this. Okay. Government in relation to the Indians was thus greatly extended, continuing the administration inaugurated by Sir William Johnson in 1744 and extended to Quebec in 1763. Ordinance for the welfare of the Indians and the protection of their lands were passed in Lower Canada as early as 1777, and a partial consolidation was made in 1840. In Upper Canada, blah, 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 so-and-so had reviewed the preservation of their settlements and their gradual introduction to the customs and mode of life of Western civilization. Then another ordinance committed the management of their lands to the Department of the Secretary of State, and by another one, comprehensive provision was made for their gradual enfranchisement and the management of their affairs. These enactments were consolidated, and this, with modifications, has now become the present Indian Act. There followed the slow but inevitable march of events paralleled by that in this country, and today there remain along the border only fragmentary reminders of that past. So now they're speaking in 1956, no longer nations, just remnants. Okay? The strife had waged over the free and ancient hunting grounds and their fruits, lands which were divided between two powers, but that life in its original mode and scope has long since disappeared. These considerations seem to justify the conclusion that both the Crown and Parliament of this country, Canada, have treated the provisional accommodation as having been replaced by an exclusive code of new and special rights and privileges. Under what authority? How can two nations divide the land of others? So there can be no doubt, the court here says, that the conditions constituted the reason to be, the raison d'etre, of the clause were and have been considered such as would in foreseeable time disappear. In other words, you were going to die off, so we really didn't need to worry about application of the Jay Treaty anymore. So these attitudes, it was okay to do this. We could ignore it. We don't have to comply with it because, they won't be here. And by the way, they're just remnants, and the only thing that exists is what Canadian the federal legislation says, i.e. Indian Act. Now be cautious, this is not an endorsement to say necessarily get rid of the Indian Act. It's a lot more complicated than that. And that's basically could be throw out the baby with the bathwater kind of thing. But the fact is, this is an attitude not that long ago. I was born 3 years after, this case. And this is why you can't rely on this as good law. And there's much that needs to be done regarding the Jay Treaty and those rights. And I'll talk about that in part 2 with the Mitchell case, what that is and is not. Thank you.